Good afternoon, everyone. Welcome to the webinar. For those who don't know me, I'm Scarlett Milligan and I'm a barrister here at 39 Essex Chambers. Today, it's my job to take you on a whistle-stop tour through my top 10 takeaways from the Law Commission's latest report on automated vehicles. Just to let you know at the outset, we are recording this webinar. It will be sent to everyone when the webinar's finished, perhaps later this evening or tomorrow. And it will, of course, be on our website where all of our webinars are archived. Now, by way of background, for those who aren't familiar, the report is the culmination of a large bit of work undertaken by the Law Commission of England and Wales and the Scottish Law Commission, lasting no less than 3 rounds of consultation papers, the first of which came out back in 2018, which to me at least feels like a very long time ago. The report is dense at over 300 pages. Obviously, we can't go through all of its nooks and crannies here today, but I'm going to take you through my top takeaways. I hope to do that within approximately 30 minutes, and that will leave us some time for some questions. We have had some questions in already. Thank you very much for those, but also we have our Q&A function live, so you can ask any as you go. 2 brief points on terminology before we begin. The title of this webinar refers to driverless cars. Really, the technical term, if you will, is automated vehicles, because of course there are varying degrees of automation. Not every automated car will be self-driving or driverless. So you'll probably hear me use those 2 terms, automated vehicles and driverless cars, interchangeably today. And then also I'd like to introduce those who aren't familiar to the term of user in charge. That's a Law Commission creation which effectively replaces the term driver, because of course, if your car is driverless, you shouldn't really be driving, you're a user in charge. So without further ado, let's begin. Well, takeaway number 1 may be familiar to some of you already because it hit the mainstream media when the report came out. And it's that users in charge will not be liable where a vehicle's self-driving mode is appropriately engaged. Now, it's a controversial recommendation, and the Law Commission's justification for it is that the law needs to have a bright dividing line between when a user's in charge responsibilities are engaged and when their actions will have legal consequences. Certainly, one can see the attraction in the simplicity of a model where the courts and litigants don't need to disentangle a factual scenario where both the user in charge and the vehicle itself have contributed to the driving, and there's a murky middle of trying to understand whose actions or the car's actions, whether they caused injury, loss, or indeed responsibility for criminal offences. But it's not entirely straightforward, because the litmus test really is was a vehicle's self-driving mode appropriately engaged? So it's not a carte blanche for everyone to sort of blame their car for everything that goes wrong. Because to give you an example, it might not be appropriate to deploy the self-driving mode on a car when you know that the environment or the terrain is beyond the car's capabilities, or for some reason you're unable to take over if the car asks you to do so. That's something we'll come back to later. You might not be able to do so because you've had a bit too much to drink, you're not feeling very well, you're tired, or for more serious medical reasons. So as I say, it's not a carte blanche. The headline, as is possibly always the case, is perhaps more nuanced when we get into the details. That leads me neatly into takeaway number 2, which is that users in charge will have no responsibility to monitor or oversee their vehicles while a self-driving system is appropriately engaged. So not only can you say effectively, it's not my fault while the self-driving car is in operation, but you can also sit back and relax, and you aren't legally required to do anything to watch your surroundings or to intervene if things look like they're going a little bit pear-shaped. That is, in fact, not just a Law Commission recommendation, it's already the law. So Section 8 of the Automated and Electrical Vehicles Act 2018 defines a vehicle that can drive itself as one that, quote, operates in a mode which is not being controlled and does not need to be monitored by an individual, unquote. So in effect, to be a self-driving vehicle in law, the vehicle needs to be capable of driving itself without monitoring. Like my first takeaway, that might strike some as strange. it might strike you as a possible missed opportunity for the law to encourage users in charge to take an active role in the safety of automated vehicles. But the Law Commission's stance is, in effect, the system and the vehicle has to be safe enough that this isn't necessary, because the problem that the Law Commission highlighted with asking humans to take on this task is that most of the time it's going to be passive. And we all know how difficult it can be to retain focus and concentration when you're not actively engaged in a task. Our minds naturally start to wander. So the Law Commission's report, in effect, says that shouldn't be a foundation for civil or criminal liability. Instead, the report suggests that users in charge have to meet the lower standard of being receptive to a transition demand. A transition demand is the way in which a vehicle signals to its user in charge that it would like the person to take over the driving, typically because for one reason or another that the vehicle has reached the limit of its capabilities. So again, like I said a moment ago, if you're unable to be receptive to that demand, so if you've had too much to drink, you're not medically fit to drive, then again, you could be liable for any injury or damage caused by the car. Interestingly, the Law Commission suggests in their report that users in charge should be restricted from sleeping and from using handheld devices in the same way that drivers currently are prohibited from using devices. I personally find that reasoning somewhat inconsistent, because the report sends a very clear message that the vehicles have to be safe enough to drive themselves. Users in charge should in effect be able to switch off. They shouldn't be on high alert. And I think it's perhaps a tad unrealistic to expect that people won't maybe drift off, at least answer a quick text or a quick email if they're disengaged from driving. Realistically, in the long term, these are supposed to be the benefits of these vehicles. I also can't see how sending a quick text, for example, is any worse than, say, reading a book. So in my mind, these are some of the knottier issues which the government is going to have to maybe look into a little bit more before introducing legislation. My takeaway number 3 is to introduce to you all the transition demand. I have already explained that that's how the vehicle signals to a user in charge that, in effect, the vehicle's had enough, back over to you, human. Transition demands are supposed to be orderly. They are supposed to give a number of effectively layered indications to the user in charge. So, for example, there might initially be a beeping noise and a message on the infotainment system that can get steadily more aggressive. So think noisier bells, perhaps vibrations on your steering wheel or in your seat, which are designed to sort of nudge you awake if you have drifted off. And ultimately, the fallback position suggested in the Law Commission's report is that if a user in charge simply isn't taking over and taking responsibilities, the vehicle needs to be able to mitigate against the risk of injury or damage. And the ultimate proposition is that the car should be able to pull itself over to a controlled stop and effectively refuse to take you any further for your bad behavior. Now, the problem with the transition demand, to my mind, at least in the way it's conceived in the Law Commission's report, is that it takes what I consider to be too optimistic a view of a system's capabilities and also the safety of the environment. So on the system side, to my mind, it's unlikely that every single transition demand will be orderly, and that in every situation, every dangerous situation, a vehicle will have enough time for this sort of gentle escalation in its demand of a user in charge, or indeed for a controlled stop. Now, the report tries to get ahead of this by saying that the system should be safe enough that it can handle all of this, or that it can keep driving if there's no such thing as a safe and controlled stop. But personally, I have some reservations. This is self-learning, AI-based tech. It will, in my view, inevitably encounter situations that it's not familiar with, that it doesn't know how to respond to. And it's certainly not reasonable to have expected the developers to have programmed every eventuality. So personally, I do foresee difficulties. And in terms of the environment, consider, for example, a smart motorway without a hard shoulder. Query how and if an automated vehicle really can come to a safe and controlled stop there. So the obligation on the vehicle is to mitigate risk, but to my mind, in coming to a stop, there may be situations where that increases the risk to the occupants. So at this stage, you're probably seeing a trend and thinking, well, it all depends how good these vehicles are and how safe they are. So that takes me on to takeaway number 4, which is there is a question mark over how safe these systems are going to be. The Law Commission recommended that new legislation introduce a test which a vehicle must satisfy before being authorised as self-driving. What is that test? Well, the Law Commission said effectively it's a question for government, because it's a political question whether we as society declare that self-driving vehicles should be of the same standard as human driving, which, as we all know, is not without its flaws, or if we demand that self-driving vehicles introduce a higher level of driving than humans. And if so, how much higher? Is it anything better than humans? Does it have to be substantially better? And as I said, the Law Commission said that's a political question. It's effectively about risk in society. So that's going to be a very technical question. The Commission has recommended that the Secretary of State for Transport publish a safety standard against which these vehicles can be measured. That is probably going to be a standard that will have to be revisited over time as the technical landscape shifts and develops. But ultimately, watch this space. It's going to be a very significant decision for the future of driverless cars. It may very well be susceptible to judicial review. We often think about this area of driverless and automated vehicles as primarily impacting, say, personal injury, product liability, insurance law, but there are certainly some big public law challenges in the offing here. Number 5, whilst we're on the issue of safety standards, my 5th takeaway is the testing and authorization system that the Law Commission has recommended implementing. The report recommends a comprehensive regulatory system for permitting these vehicles on the market and then allowing them to operate on the roads. I can't do it justice in these top 10 takeaways, but in a nutshell, it's comprised of 2 levels. The first is the authorization, initial approval stage. Many in the audience will be familiar with a manufacturer's obligation to obtain approval for different systems and components. They then have to go on and obtain approval for the whole product, in this case, a vehicle, and ultimately to obtain type approval. And that allows a manufacturer to produce that type of vehicle using the same combination of systems and components in more significant quantities. And it means you're not putting every individual car through the approval process. Now, the Law Commission say that the approval process should get the car on the market, but not necessarily self-driving on the road, because the second stage of authorization should be that the vehicle gets tested to ensure it meets the standard of being able to drive itself safely, legally, and without monitoring or supervision. So at that point, all the nuts and bolts that we've covered so far should be being thoroughly tested. And bear in mind that the approval can be qualified. So an approval may indicate that a self-driving system is allowed on the motorway when things are a bit easier, but it isn't perhaps quite ready for some of the twisty, turny A roads of our beautiful countryside. Takeaway number 6 is an introduction of the authorized self-driving entity, or ASDE. That's the body that the Law Commission recommends should put the vehicle forward for authorization and effectively take responsibility for it. It could be a manufacturer, a software developer, or a mixture of companies, but the Law Commission suggests that it ought to show it was closely involved in assessing the safety of the vehicle. As I said, the Law Commission recommends that all self-driving vehicles should have an ASDE behind them, and that would mean that that body stands effectively as responsible for problems with these self-driving vehicles and would be a point of contact for the regulator. If self-driving systems malfunction, that would be something that the regulator would pick up with the ASDE. And for that reason, the Law Commission recommend that every ASDE should be of good repute and have appropriate financial standing, or at least access to funds, because if problems arise and the ASE needs to pay out compensation, to pay financial penalties, or to issue a recall, they need to have the means and the resources able to do that. That leads me into takeaway number 7, which is the ongoing post-authorization regulation of self-driving vehicles. The process I was just describing is a 2-stage process for getting the vehicles out on the road. But what the Law Commission recognises is that really the safety of these vehicles is going to require continuous regulatory oversight throughout their life, because, as I said earlier, this is AI, it's self-learning, it's continually moving and evaluating its surroundings and learning from them, adapting from them. So these systems will change, the environment will change, and they're going to need regulatory oversight. So to that end, the Law Commission's report recommends the establishment of a safety regulator. That's not the same body as the one we talked about a moment ago that would be charged with the initial approval or authorization of these vehicles. This would be a separate body responsible for the continual monitoring of the vehicle's safety and legal compliance, and that includes errors and accidents. The Law Commission recommends that regulator should have the power to issue sanctions and penalties where there are accidents or errors. But interestingly, this report stresses in more than one place that the onus should not be on determining fault, but it should be about learning lessons and improving safety. That is likely to mean that ASDEs standing behind these self-driving systems are unlikely to be penalised for every accident, error, or omission. The regulators are more likely to be looking at serious accidents or perhaps trends across vehicles. That said, the report did recognise the scope for an independent specialist collision investigator where the accidents are serious or complex. I suspect that would function much like we have at the moment with the air accident investigation branch or the marine accident or rail accident investigation branches. Importantly, if that investigator did function in that same way, that may very well mean that the data which forms part of a major investigation is ultimately not disclosed to the public, which is the case with those investigation branches at the moment. So the idea behind that, for those who aren't familiar, is that it encourages full disclosure of the facts and the details to the regulator with the intention of improving safety standards and really learning lessons, rather than a closing of the ranks effectively to keep information inside. So that would be very important for those litigating in this sphere. Takeaway number 8 is a forecast of my own, and that's that this emphasis on learning lessons is unlikely to spell the end of civil liability for actions for injury or damage arising out of the use of driverless cars, because it's all well and good wanting to focus on improvements in safety and learning lessons, but as many of you will know, that's unlikely to be sufficient comfort to a severely injured claimant who has potentially lifelong afflictions and health needs. The Automated and Electric Vehicles Act 2018, as I mentioned earlier, that act introduced a new regime for compensation victims, for compensation claims for victims who are impacted by driverless car collisions. Again, I can't do that whole act summary in this webinar. It's probably a webinar of its own. But in summary, Section 2 of that act provides that where injury or damage is caused by an automated vehicle driving itself, the insurer of the automated vehicle is liable for the damage. It initially can strike one as something like a strict liability system, but not quite, because the insurer has the ability under Section 5 of that act to, in effect, step into the shoes of the claimant and bring a subsequent claim against the person or entity that is ultimately responsible for the damage, using the same cause of action that would have been open to the underlying claimant. So the act actually functions in effect as an insurance shortcut for victims to obtain, at least in theory, swift compensation, rather than ending up in a messy fight in the courts the very first time that we see a driverless accident on the roads. Just a couple of important points to bear in mind by way of introduction to this compensation right under Section 2. The Act makes provision for contributory negligence deductions, that's Section 3. And the claimant must establish that the damage complained of was caused by the automated vehicle driving itself. Sounds straightforward, but actually I think that could be fertile territory for disputes, particularly when we think about the early days of the introduction of AVs, and where you may have a collision between an automated vehicle and a non-automated or ordinary car. And finally, Section 2 only applies where a vehicle is insured at the time of the accident. At the moment, there is no equivalent of the MIB insurer of last resort arrangement that we have for other cars. That's something the Law Commission has, of course, picked up on in its report, and it's recommended that the government address that in forthcoming legislation. Takeaway number 9 is the impact on product liability laws. As I've said, claimants are more likely to use the simple structure of the Automated and Electric Vehicles Act Section 2 claim that, in theory, enables them to claim swift compensation and to address their needs. But where manufacturers are responsible for accidents, it's unlikely that insurers would shy away from a product liability claim against a manufacturer using their Section 5 claim, as I said, where they sort of step into the shoes of the claimant, as it were. And because the insurers do step into the shoes of a claimant for the purposes of Section 5, that means that you have a rather unusual position where an insurance body can bring a claim under the Consumer Protection Act 1987. So because the claimant was in effect an underlying consumer. Now, there are many difficulties in applying that act, the Consumer Protection Act 1987, in the context of automated vehicles. I don't have the time to go through all of them today, but a couple at a high level are that the claimant is unable to recover for the cost of the damage to the product itself. When you're talking about some of these self-driving vehicles, that's going to be an enormous cost that the insurer will have to pay out, but will not be able to obtain from the at-fault manufacturer. And secondly, perhaps more importantly, there is an ongoing debate at the moment as to whether the Act applies to software when it is divorced from hardware. So, for example, could you bring a Consumer Protection Act claim for a collision caused by an over-the-air software update provided by a manufacturer that is separate from the manufacturer of the chassis of the automated vehicle and is not in any sense dependent on its hardware? So those, as you can imagine, are just two of a number of problems, and they're not small by any means. So the Law Commission's report addressed this relatively briefly and effectively said that a more general review of product liability is desirable, but they said it's not essential for the successful introduction of self-driving cars. My view is that really it's absolutely essential for the appropriate regulation of emerging technologies, because I think without a review of product liability laws in this area, what will happen is that we will see the insurance industry being unable to recoup its payouts from at-fault manufacturers and possibly effectively soaking up a gap in the regulation, which is not at all appropriate. And I can't see this being limited to an issue with automated or self-driving cars. Our lives are increasingly becoming intertwined with technology. There's going to be a lot more smart devices around our homes. So really the law needs to keep a pace with that and needs to accommodate these technologies. So in my view, a product liability review or reform is really overdue. We are seeing steps being taken elsewhere and indeed in the EU to have a look at how product liability law should be reformed to accommodate modern technologies. So we're a little bit behind the curve, but hopefully government will get the message loud and clear from the Law Commission report and instigate that review. My 10th takeaway and final is, I've named it a little quip, not in my backyard, because the Law Commission have said that their report and the recommendations as to forthcoming technology should only apply to roads and other public places. The recommendations don't apply to private property or to environments with restricted access. And the examples given in the report were ports, quarries, or private car parks with barriers. So in effect, if you get a self-driving car, you tweak it, you can do what you like on your own land. The report suggested that in areas where it's private property, but there are various individuals around and affected, the Health and Safety at Work Act 1974 and the two Occupiers Liability Acts both provide a sufficient legal framework for disputes involving automated vehicles in those contexts. Now, that may very well be right. We all know that the law and the courts are adept at considering how specific environments or equipment have an impact on an occupier's or an employer's liability in varying facts and scenarios. But what I would say is that the Law Commission is, in effect, leaving the use of these vehicles in those contexts completely unrestricted. It's a bit of a Wild West, as it were. And without more, it's going to be for the courts to police where the boundaries are, how these vehicles can be used appropriately, and how they should be used. That is going to take time. It will necessarily be iterative, and there'll be an awful lot of uncertainty for a good amount of time. For employers, there is also the added complexity that a fully driverless vehicle in years to come is likely to be an employee's workplace. One of the big benefits of this technology is that we can enhance our productivity and we can sit in vehicles and do our job whilst we're being transported from place to place. So the vehicle being the workplace, as those of you who practice in this area will know, that brings a whole host of additional obligations and new level of complications. So those were my top 10 takeaways. Looking at the clock, I'm just 2 minutes under, but thank you for sticking with me. And I'm now going to cast my eye over the Q&A box and pick out some themes and some questions that are emerging, as well as answering a couple of the questions that were submitted in advance. Now, one question we have is, what are the privacy implications for driverless cars? There are quite a few. These systems are going to harvest a lot of data. That's not just going to be crash collision data. And bear in mind also that the crash and collision data needs to be retained somehow for the entirety of a limitation period. Off the top of my head, I think the Law Commission recommended 3 years and 3 months retention of data in order to accommodate the claims that are brought on the eve of limitation. But as we all know, sometimes limitation can run longer if someone is incapacitated or a child. So there's going to have to be a lot of collision data stored. But on top of that, there'll be personal data stored by the vehicle. There'll be sensitive personal data. Many cars have, at the moment, a feature akin to Apple's Siri, where you effectively say hello to your car and you ask it to do something for you. So the cars are already, in effect, being primed, if you allow them, to listen to your conversations and to be ready to take in a command. That means that all of that data, all your conversations are going to be stored. You can imagine that the vehicle will have records of where you're going and when. So if you visit a place of worship, it might be able to infer your religious beliefs. It might be able to detect patterns. It'll probably be linked with devices and apps. So really, there's going to be an awful lot of data held by these systems. The Law Commission's report recommended that ASDEs, the entities behind the car, should present regulators when the car's going through the approval and authorization stage with details of how data should be recorded, stored, accessed, protected. And the Law Commission basically said these vehicles should only be being authorized if there are sort of GDPR compliant or data protection law compliant systems in place. But I don't think that's going to be the end of the story. We're seeing a lot of data protection litigation en masse in the higher courts, and so I think it's a challenge that we will be seeing with driverless cars. Somebody's asked what's the next step. So the Law Commission report is in effect a mammoth report that's intended to lay down a roadmap to a chunky piece of legislation by the government. So yes, the government will need to take away this report. They'll have to consider it. They may very well disagree with it. But I think because of the technicality and the expertise required in this area, and the expertise certainly that's been fed into the Law Commission's report, I think on the whole, the government are more likely to adopt the Law Commission's recommendations, and they'll need to put together a comprehensive piece of legislation that will pave the way for these cars to come onto our roads. I'm not sure how long that will be, and I certainly wouldn't be able to make any promises. What are the implications for civil litigation? Well, I've already addressed some ways in which the laws in this area will need to be changed. That in and of itself may have some knock-on consequences for other areas of law. But I think, as I said earlier, I think civil litigation will continue, at least in the short to medium term, and victims are still going to want compensation. The main impact that I see this having on civil litigation and on courts is that litigation involving any self-driving car, to my mind, is going to be expensive and it's going to be technical. So what we have at the moment is road traffic accidents that are the bread and butter of our court system, even sort of minor scrapes, disputes over whose fault a scratch may be on a car, or very minor injuries like whiplash, and they are dealt with in a proportionate way in the lower courts, and with very controlled evidential procedures and fixed costs. Now, the difficulty will be that even with those kind of cases, with a self-driving vehicle, there may be black box data. It's no longer just a question of two people in court having an argument and the judge deciding who he or she prefers. So there could be a lot of black box data. We've talked about that. It's likely, I think, that the courts will need expert assistance in interrogating and interpreting black box data. And bearing in mind that some of the smaller county courts around the country do already struggle if a court case presents dash cam footage or CCTV from a bus, I do have some reservations about how all of this material is going to be adequately presented in some of the courts. And bear in mind also that there could be a great number of parties. So even if there are only two drivers, well, there are the two drivers. If let's say the vehicle's not entirely self-driving, those two drivers may have played a part. There's the two manufacturers of the car's components. There's the software installers, garages installing updates. The list goes on. I mean, it's not necessarily going to be the case that every single party will be involved in that dispute, but there are avenues of investigation, and it's all going to build into costs. So I think that will have an impact on how we litigate road traffic accidents and low value damage claims. And we'll have to ask ourselves whether the system is still working for those kind of disputes. I have wondered in the past whether that will mean we are effectively forced into a insurance-backed no-fault system, because it's simply not appropriate, as I say, to keep going to court to disentangle all these issues at great cost for relatively little gain. It might be that's a sort of legislative move, but it might also be that it's one that comes simply by virtue of the fact that the litigating parties recognise that it's just not worth thrashing these issues out in court, and insurers taking that course of their own accord. Who will be liable for injuries caused during the transition period? Well, the basic concept, if I can drill it down to its essentials, is that the Law Commission recommends that in general, a user in charge is not liable during the self-driving systems when they're appropriately engaged, nor for events that occur during the transition period. But as soon as that transition period comes to an end, the user in charge sort of regains control and also regains regains responsibility and potential liability. The one knotty area or exception is where the actions of a self-driving system during the transition period in particular, in effect, sort of line up an accident. So let's say the vehicle is doing something rather strange during the transition period because it doesn't know what to do. That's why it's asking you to take back control. And in its actions, it makes an accident or a collision inevitable. But it just so happens that at the precise moment of that collision, 3 seconds earlier, it's you as the user in charge who took over and you have your responsibility back. The Law Commission report suggests that drivers should have a get out for liability in the period immediately after a handover, if they can show that their driving did not fall below the standard reasonably expected of a competent driver. That was a recommendation that was made in relation to criminal offences. It wasn't necessarily applicable to civil litigation, but I suspect that will be how the courts tend to look at these cases in a civil context. There'll be specific fact patterns. I don't think it will be appropriate to say you sort of have a 10-second window or anything like that. But again, this brings me back to one of the first two takeaway points that I offered. I think it's very difficult to draw a bright dividing line and to simply say, well, no, these systems should be good enough and you don't need to watch, you don't need to do anything, don't worry about it. Because when these transitions happen, they can be relatively short, and immediately after you're liable or potentially liable for things that go wrong. So I don't think it's as straightforward as expecting the vehicle to be able to do everything, and that we should switch off, particularly in the early years of the introduction of AVs. And bearing in mind, as I've said before, that this technology will be in development. I think it's unlikely that any manufacturer is going to produce a sort of perfect AV overnight. So it's something we definitely need to keep an eye on. I've been asked to what extent or under what circumstances can the victim hold developers liable, and is there any scope for contributory negligence? So the Section 2 AEVA claim that I mentioned earlier is in effect a shortcut. So you can sue an insurer for your injuries and for your losses, and that in theory takes all the heat out of it for you. You get your compensation, you let the insurer deal with bringing a claim against the manufacturer. It is possible for an individual to go directly after a manufacturer, bring in a sort of product liability claim in the way that they might do now. So the AEVA 2018 doesn't say, for example, this must be the course of action that you take. It extinguishes other causes of action. But to be honest, I think it's highly unlikely that a sort of victim would take that course. I think it's much more likely that they would take the sort of swift compensation option that's available to them. But yes, it is possible. And is there any scope for contributing negligence? Yes, there is. That's explicitly recognised in Section 3 of the Act. The Law Commission suggests that the Automated and Electric Vehicles Act 2018 is good enough for now. Given your earlier comments, do you agree with this analysis, or do you think the AEVA should be looked at again? I think on the whole that the AEVA is effectively, as I just said, a transference of risk and transference of the logistical nightmare that realistically will be taking these cases to court for the first time. And I think they will be, as I've said, technical, complicated, drawn out litigation. So I can definitely see the sense in the mechanisms of the AEVA. It's quite claimant friendly, but I suspect that's a decision that's been made to try and put the public at ease when it comes to the introduction of these vehicles. I don't think it's perfect, far from it. There are some problems, particularly when you start to get in the sort of theory of how it is that an insurer can effectively step into the shoes of a claimant. But I think I probably tend to agree with the Law Commission that it will sort of do for now, but it probably will need revisiting. It may very well be that it makes sense to encompass that revisitation of the 2018 Act into a whole big new piece of legislation that the government is going to have to put forward following this report. So it may make sense to do it there. So I guess watch this space. When will someone be liable for failing to respond to a transition demand? So this is slightly complicated. The Law Commission suggested that not responding to a transition demand, so this is when a vehicle is saying, please take over, I don't know what I'm doing, back to you. The Law Commission said that failing to respond, let's say you can't be bothered, you're drunk, you're in a very deep sleep. And the Law Commission said that probably shouldn't be a criminal offence per se. But what may be a criminal offence is the situation in which you find yourself following the end of the transition demand. So as I was getting at a few minutes ago, if at the end of the transition demand, there is an accident, you may be liable for that. If the car has brought itself to a stop in the sort of far left lane on a smart motorway and you cause a pile-up, you may very well be liable for that. So it's looking at the circumstances as at the end of that transition demand, rather than a sort of a reason or failure to respond to a transition demand per se. And we've just got one more question. Are manufacturers going to have an upper hand as against the regulators? That's quite hard to answer. I suspect it might be a question of resources. This is going to require a lot of technical expertise. It's feasible that a lot of that tech expertise will have stemmed from the R&D departments of large companies that are developing this tech. I think it's understandable that assessors may very well effectively be on the back foot of assessing technology compared to those that have developed it and are sort of presenting it in its best light. But this is the sort of bread and butter of approval processes and regulators. So I'm sure systems will be put in place to make sure that those assessments are adequate and that they're very wholesome. What I would also say is that the Law Commission has recommended a duty of candor on the ADSEs, so the entity backing the vehicle, and there are some possible criminal offences for failing to disclose key information. That's probably a bit beyond the scope of this talk, but that's relevant consideration for that question. We haven't had any further questions, so looking at the time, I suspect everyone just wants that final 15 minutes to grab a sandwich or a coffee before getting back to work, which is perfectly understandable. So thank you all very, very much indeed for joining us today. We really appreciate it. and hopefully we'll see you back here soon when the legislation hits the books. Good afternoon.